Ladies and gentlemen, I welcome all to my channel. In our series of videos, you are seeing the various aspects, important aspects, which we have to bear in mind in purchasing and selling the property. In my first video, we have seen one of the main aspects, namely the importance of the original sale deed. What are the consequences which may arise in the event of the loss of the original document, and what will be the risks, what are all the possible frauds in the event of non-availability of original title deed, as discussed in my previous video. In this second video, we are going to see the second important aspects, namely the parent deed. So when we are going to purchase the property, we should not only see that the owner or the seller has the original of the title deed. We should also see that he has all the parent deeds. You may ask me a question: what is meant by original deed, and what is meant by title deed, and what is meant by parent deed? Supposing we are going to purchase a property from A, the document, whether it's a sale deed or a settlement deed or a partition deed, through which A got the property. Suppose A got the property by way of sale, he might have a sale deed. Suppose he got a property by partition or by settlement, he would have a partition deed or settlement deed in his favor. That type of deed is called title deed. The A might have got this property from one B. So the B might have got the property from C. So the document which is in favor of B or the document in favor of C are all called parent documents. Simply saying, the sale deed, which is our sale deed or any other document which transfers the property to in favor of the vendor, seller, is called title deed. All documents prior to the documents are called parent deeds. So, when you are going to purchase a property, you should not only see that the seller has title deed in his favor, he should also possess all the parent deeds. All the parent deeds relating to the property should be available with him, and he should hand over to us. Then only we will get a perfect title over the property. In case he did not have such document, then there is a possibility that there is a fraud, or there is a possibility that there is a risk, there is a possibility that there is a case. These are all the risk factors involved in the event of non-availability of the original parent documents. Simply saying, suppose A has the property in his favor, he sells the property to B, then what he will do? He will not only execute a sale deed, he will also hand over all the title deeds related to the property to B. Then B sell the property to C. Then what B will do? He will transfer his sale deed. In addition to that, he will also hand over all the documents given by the A. So likewise, all the documents, all the title deeds and all the parent deeds will transfer to all the subsequent transfers. If such things happen, then there is no risk, there cannot be any fraud. So in case suppose some documents are not produced, not handed over, then in that case there is a possibility that there is there might be a case, or there might be a mortgage, or there might be a sale agreement, or there might be a deposit of title with respect to that that document which is not available with the seller. So we should bear in, when you are going to purchase the property, we should not only ask the seller to hand over his original title deed, you should also ask him to surrender, to hand over all the parent deeds. Before purchasing a property, we should scrutinize all the documents, original documents, whether the vendor has all the original documents, including the title deed and as well as the parent deeds. If the document is, all the title deeds are with him, then we can proceed for proceed for the sale of the property, and then only thereafter only you should go for execution of the sale deed. You may be asking a question. Supposing the seller is owner of the 6 crores or 6 acres of property, and he is selling only a small portion of, say, 10 cents or at least 1 grown, then how can we ask him to hand over all the title, the entire document? That's an important question. This is a very important question. In such circumstances, we cannot ask the seller to hand over the entire documents. So, supposing A got 4 properties through a partition deed, and he wanted to sell the property. Out of the 4 property, he wanted to sell one of the property to subsequent purchaser. So in that case, the A will not hand over all the original documents related to the property, because if he hand over all the documents, then he may not have any document, title deed, with respect to the remaining property which is retained by him. So in that case, what should we do? In such circumstances, the A should write in the sale deed saying that I am not selling the entire property, I am selling only a portion of the property. So I am not selling all my property and I am selling only one of the property. So for that reason, I am retaining my sale deed or retaining my partition deed, and I am retaining all my parents' deed, and I'll undertake to produce the original document to any court or any government officer as and when required. Like that, there must be a clause in the sale deed. If such clause is there in the sale deed, then it is safe. Then on the basis of that sale deed, the purchaser, not only the purchaser, all the subsequent transferees, all the subsequent persons who purchase the property will have right to claim the original document holder to produce a document in the court of law, or to produce a document to the bank as and when required, or to produce a document to the government officers as and when required. So such type of wordings, such type of clause should be there in the sale deed. So in addition to that, we should also get a Xerox copy of all the parent deeds, and you should also get a notary attestation attesting on the date of registration. That will helpful to you to avoid any possible risks in future date. Assuming for a moment, I am purchasing a property on 1st January. So the seller has 4 properties. Out of his 4 properties, I am purchasing only 1 property, and the original owner is retaining the original document because he has retained another 3 properties. So on that date, I asked the seller to produce the Xerox copies of all documents and produce all the documents to the notary public and get it attested, attesting that it is a true copies of the original. I compared the Xerox copies of the documents with the original, and this is certified to be the true copies, and he put a seal with the date. In that case, it will be helpful to, supposing after that date, suppose if any person comes and makes a claim saying that the original document is deposited with him, and there is a loan, there is a mortgage by deposit of title deed, and he send a notice or makes a claim in the court of law, then you can produce the notary attestation document saying that on the date of the execution of the sale deed, all the original documents were with the seller. He produced the document to the notary public. The notary public verified the document and given attested saying that this is a true copy. So that means on the date of execution of the sale deed, the original documents are with the particular seller. So I got the property on the particular same date. So subsequent to that date, suppose that original document is given to any person and obtain a loan, then he has no authority to deposit my property which is already sold. So even if any mortgage is created over the entire property, that mortgage will not be binding on my property because it was already sold. So that type of deposit of title deed or that type of mortgage will be binding only with respect to the remaining property which is not sold to me. Like that we can make a claim and we can make a defense in the court of law. So in such circumstances, we should make this kind of safety measures. Now you may be asking the third question. So how long, to what period we should see that the original documents? How long we should ask? To what period? Up to what period the seller should produce the documents, parent documents? In my opinion, if he is able to produce 100 years or 200 years or 300 years, it is beneficial to you. If you see the title document and if there is a title history, and if he is producing all for 300 years from the British years, it is safe to you. If it is available, it is good for you. If it is not available, at least you request him to produce the document at least for 40 years or at least for 12 years. So law of limitation says that if a person is in the occupation of the property for a period of 12 years, as per the law of prescription, he will get the absolute title over the property under the law of prescription. So draft prescription will not apply to government properties or public properties. So in that case, at least there must be 30 years of occupation, absolute possession is necessary. So to avoid or to perfect the title, let us ask them to produce at least 40 years periods parent deed. That will be very safe to us. So these are all things we should keep in mind in purchasing the property. So in my first video, I have mentioned that original sale deed is must, and this video we are making it clear that the parent deeds of the property and the originals of the parent deeds are mandatory. So you should purchase only those properties in which the original of the sale deed or originals of the parent deeds are available. In case any of the document is missing, you should have thorough verification and you should have analyzed it properly, and we should find out all the risk factor, and we should thoroughly check and rule out all the possible risks. Then only you will have to purchase the property. So these are all things we have covered in first and second videos. Let us see in the next video, the third aspect in the next video. You may have viewers, you may watch my YouTube channel. So you may watch my Razyak Sattam Arivom Tamil channel or Razyak LawTube English channel, or you may directly click my website Ali Associates, which is available, which is mentioned in the last portion of my video. From that, you can directly click my website and you can view English videos and Tamil videos. Whatever be your legal doubt, you can just click my website and you can click the playlist and you can see the relevant videos and you can clear all your doubts. In addition to that, if you have any specific doubts or queries or you need any consultation, you may contact my cell number. If time permits, I will give you online consultation on prior appointment. Thank you. Goodbye. Razyak Ali.